Okay, let's start. Good evening, dear speakers and dear participants. Thank you for joining this Ukrainian Arbitration webinar, Ukrainian Arbitration Association webinar. And today we will discuss various developments in investment treaty arbitration. My name is Olena Perepolinska. I'm president of the Ukrainian Arbitration Association and head of arbitration at Integritas in Kyiv. And before we start our discussion, I would like to introduce our speakers. Bart Legum is a partner in the Paris office of Dentals. He is the firm's global co-chair for litigation and dispute resolution. He also serves as a member of board of Arbitration Institute of the Stockholm Chamber of Commerce, and was named by the president of the World Bank to the ICSID panel of conciliators. Early in his career, Bart served in the US Department of State and the lead lawyer for the United States government in early investment treaty arbitrations against it. Julia Chernych is currently associate professor in law in Norway and vice chairman of the International Commercial Arbitration Court at the Ukrainian Chamber of Commerce and Industry in Ukraine. Her recent particular experience with ISDS relates to expert testimony on points of Ukrainian law in ICSID and PCA proceedings, and her academic focus in ISDS turns around conflict interpretation or more broadly implication of contractual issues in treaty-based cases. And last but not least, Ejjan Askan is the head of arbitration department of Turkish law firm Lexist. During the last 10 years of his career, he has represented many Turkish investors in their ICSID arbitration cases, filed against various countries like Turkmenistan, Uzbekistan, Oman. On the other hand, he was also involved in the teams representing sovereign states such as Romania, and currently he leads the arbitration team representing the Republic of Turkey in 2 ICSID cases. So, I suggest to start our today's discussion with more general topic of reform of ISDS. So, Barton, could you please tell us about it a bit more?
With great pleasure. So thank you for the introduction, Olena. And as you've just said, I'm going to address from a very broad perspective an important trend in investment treaty arbitration today. And that is the movement towards reform of the system of investor-state arbitration under treaties. Now, before going into some detail on the proposals for reform, I would like to provide a bit of context and provide an idea of the timescale for reform. The context is the current system of investment treaties. The current system is characterized by some 2,600 investment treaties in force. These treaties were negotiated by different states over a period of a half-century. The treaties have different texts and negotiating history. They typically provide that they are renewed automatically and will continue to protect covered investments even after termination for a period of 5 to 25 additional years. Now, the arbitration provision in most of these treaties is quite simple. This means that the procedure in investment treaty arbitration is determined by the applicable rules in large part. However, a small but growing number of recent treaties spell out the procedure in great detail. This more recent generation of some treaties promulgated by some states can be seen already to reflect one kind of reform. Now, a word on timescale. The word in English is spelled S-L-O-W, slow, very slow compared to the commercial world. If you like the reforms implemented by the London Court of International Arbitration in the rules that it promulgated last month, you might include an arbitration clause referring to those rules in a contract that your client or your company negotiates tomorrow. The first dispute under that contract might not occur until 2 years from now, let's say in 2022. So it would be in 2022 that the LCIA reform impacts a pending dispute. That is the time scale of reform in the commercial arbitration world. In the treaty arbitration world, things move much more slowly. The world around you today is likely to be the only relevant one for many years to come. The multilateral discussions on investment treaty arbitration reform at UNCITRAL likely will not conclude until 2022 at the earliest. If one of the solutions adopted is a multilateral convention on the topic, it will likely take years for that convention to be negotiated and years after that for it to enter into force. In other words, the trend towards reform is an important trend, but it is not one that will have an impact on decisions you will make in the near or medium term. If your client's business is one that considers 10 years from now to be the long term, it likely won't affect any decision you make for the long term either. The discussions on reform are being held, as I mentioned, under the auspices of UNCITRAL, the United Nations Commission on International Trade Law. This is a small UN organization based in Vienna. The discussions revolve around 3 issues: consistency of arbitral decisions, the independence and impartiality of arbitrators, and the cost and duration of investment treaty arbitral proceedings. The consensus of the UNCITRAL working group is that some sort of reform should be sought to improve these 3 issues. The question now before the group is the hard one. What form should the reform take? And there are essentially 2 approaches to this question. The first is advocated by the European Commission. It wants to put into place a multilateral international court for investment disputes. This would be a transformative reform of the current system. It would replace a system of arbitration with an international judicial system. The second approach, favored by a number of other countries, is for smaller, more incremental reform of the arbitration system. Now, the dialogue concerning the 3 issues that I mentioned earlier divides according to these camps. If your starting point is that any form of dispute resolution involving a state should look like a court, then arbitrators do not look independent and impartial compared to judges. Arbitrators are not full-time adjudicators. Most have day jobs like professor or lawyer. In arbitration, a party ordinarily can pick at least one arbitrator. Often, a party will pick an arbitrator because that party believes the arbitrator will understand well the party's case. Parties generally cannot pick judges. Because of this difference in features, arbitrators may appear less independent and impartial than judges. Now, to be clear, there is no endemic problem of arbitrator bias or corruption in investment treaty arbitrations that has been identified in the reform discussions. Instead, there is a difference in perception as to the qualities of the desired adjudicator. Similarly, the cost of an arbitration is borne entirely by the parties to the dispute. In many legal systems, the cost of a national court is borne entirely by the taxpayers of the country, not by the parties to the dispute. The cost of a multilateral international court is borne by all states party to the court's statute, but often with developed countries paying much more than developing countries. For a developing country with multiple cases against it, arbitration will be much more expensive than the country's dues for an international court. Again, one's perception of the cost of arbitration depends in part on whether your starting point is that of a court or of arbitration. Similarly, international courts are better equipped to achieve consistency in decisions than international arbitration tribunals. Arbitral tribunals are composed of different people for every case. Courts may be divided into chambers, but there is a relatively small number of judges, and therefore a greater likelihood of those judges taking the same approach in similar cases. Now, there are, of course, good things and bad things about each of the options of arbitration or court systems. Consistency in decision making is a wonderful thing as long as you like the first decision that was made. If you don't like that decision, then the consistency that comes with a court is a problem. There is a material difference between telling one arbitral tribunal that another tribunal got it wrong and looking judges on a court in the eye and telling them that they got it wrong. For some cases, being able to name an arbitrator with a background that allows her to really understand the technical issues presented can make all of the difference in arriving at a just result. By contrast, sometimes the excellent legal training of judges leaves them ill-equipped to deal with a case that depends on a complex financial structure or a technical understanding of the equipment at issue. In my mind, in the end, the reform of investor-state arbitration will depend on the answers to two questions. First, how comfortable are governments in transferring power to a new international court with the power to decide on the legality of national legislation and the conduct of their nationals abroad? Second, will the spirit of multilateralism prevail over the divisions that we see in the international community? Will that spirit bring countries together to create a powerful new multilateral court? Now, it's not obvious to me today that either of these questions will be answered yes, but only time will tell. That concludes my brief overview of this topic, and I look very much forward to the discussion.
Thank you very much. So my first question, so as you mentioned, this is discussed in UNCITRAL. Are there any current issues that are discussed in particular?
Well, right now, a main topic is a possible appellate mechanism for arbitration or dispute resolution under investment treaties. And this is an extremely complicated topic, which will look quite different depending on whether there is, as the European Commission advocates, a single international court on investments, or whether we retain the current system of arbitration. So that's one of the main issues, is how to structure an appellate mechanism and how to graft it onto the current system of treaties, because one of the things that's not being discussed right now is coming up with a single treaty like the WTO agreements that would have a single dispute resolution mechanism. Instead, the concept is to create a court, or perhaps maintain the existing system, but have that court or the reformed system address disputes under the 2,600 treaties that are currently in existence. So it's a complicated topic. The other topic that is very much on the agenda today is a draft code of conduct for adjudicators in investment treaty arbitrations. And there's been a draft put forward by ICSID and UNCITRAL for consideration by states that is being actively discussed right now.
Okay, very interesting. And is the COVID pandemic has any impact on this, on the progress of this discussion and reform?
It doesn't have much of an impact on the discussions in the sense that the state representatives continue to participate in webinars organized by different governments, by different arbitral organizations on the topic of what I've just referred to, the topics that are under consideration by the working group. In terms of the working group itself, however, COVID is having a significant impact because in-person meetings are not really possible right now. And there are some countries that really don't want the discussions, the formal discussions, to move forward until they can meet again in person. So there's a little bit of a hiatus there.
Okay, thank you very much. So let's move to our next topic. Julia, taking into account your academic focus and your experience, could you tell us a bit about contractual interpretation and international investment arbitration?
Certainly. It's a big pleasure for me to have this opportunity to discuss contract interpretation. And there is actually a very smooth tone from the topic which Parton addressed, ISDS reform, because when we are talking about reforming investment treaty arbitration, we are talking about consistency in decision making. And one element of consistency is the proper application of domestic or national law. We spent a lot of efforts in discussing treaty interpretation in investment treaty arbitration, and rightly so, because it's primarily public international law, bilateral, multilateral treaties which are applied in investment treaty arbitration. And we, unfortunately, or fortunately for me, spent not much efforts discussing contract interpretation. So I have spent 4 years in researching this area, which I find extremely interesting. And I will show, I will try to show now and share presentation. So contracts appear central for many investment treaty disputes, primarily because of investment contracts, concessions, privatization agreements, various kinds of agreements. And they appear in focus for tribunals who have to reason in relation to these contracts. So when I started to research this topic, I decided to have an empirical grasp of what kind of contracts, what kind of contractual provisions are in focus for tribunals, how do they approach contracts. And I reviewed all arbitral awards available by January 2019. I selected out of those awards where there were some elements of contract interpretation, and my threshold for identifying what is contract interpretation and what is not contract interpretation was rather low. So I tried just to analyze and to see how tribunals address contracts in the context of investment treaty arbitration. And to my greatest surprise, I discovered that the range of this contract is quite broad, that it is not only concessions, it is not only privatization agreements, it may be donation, it may be pure share purchase agreements, it may be various kinds of agreements of commercial nature, which we can imagine. And in terms of contractual provisions which are interpreted by tribunals, it's not only stabilization clause or equilibrium clause, which is frequently addressed in the context of investment treaty arbitration. It is also termination agreement clauses. It is clauses relating to various kinds of undertakings which parties promise to each other. It may be forum selection clause. It may be provisions on applicable law. So it's pretty much a broad scope of contractual provisions which are in focus for investment treaty arbitration and which are quite similar, not identical, but quite similar to what we normally see in the context of international commercial arbitration. So I was very happy to find 128 cases with elements of contract interpretation, and I analyzed those cases, and I discovered that in many of these cases, national law applicable to contracts is not properly applied. And when tribunals address contractual provisions, they are not referring or not applying national law. And there are many explanations for this, primarily because tribunals are applying public international law, and in some contexts, national law may be viewed as a question of fact. But in some disputes, national law is part of applicable law, and for those disputes, it might be quite problematic not to apply national law applicable to contracts. And I have discovered a diverse and broad range of treaty-related issues or public international law issues for which contract interpretation is necessary. Tribunals interpret contracts for deciding on jurisdiction. They interpret contracts for deciding on fair and equitable treatment or expropriation. They interpret contracts normally for deciding on umbrella clause, but it's not the only aspect which they consider. It may be also compensation, for instance, a limited liability clause. Does a limited liability clause in a contract has impact on compensation, and whether the tribunal has to ascertain what actually the parties meant when they agreed on limited liability or on penalty clauses. So it was extremely interesting for me also to discover a rather broad spectrum of questions which normally appear in the context of investment treaty arbitration and which require contractual interpretation. I haven't stopped there. I haven't stopped on empirical observations. I tried to analyze this doctrinally or normatively in the sense that I tried to provide an answer how tribunals should interpret contracts. What is the relevant framework for their interpretation? And for instance, if we talk about treaty interpretation, we normally mean Vienna Convention on the Law of Treaties as an applicable relevant framework which assists in identifying relevant principles of interpretation. But what happens when we talk about contract interpretation? And in this context, we have national law. International law doesn't govern contractual interpretation, and it is national or municipal or domestic law which regulate contract interpretation. And that's quite a normal approach because contracts are creatures of national systems. Of course, there are some theories of transnational law, and I discussed this also in my book on the limits of transnational law and the primary importance and relevance of national law for contract interpretation. And I came to a conclusion or suggested that tribunals possess power to invoke and develop independent legal reasoning, and that legal reasoning in relation to contracts should be based on applicable national law to these contracts. In my book, I also discuss various much more complex issues. Probably we don't have time for this in the framework of this webinar, but I will just name them. I look at failures to apply municipal law. I look at wrong application of municipal law, legitimate non-application municipal law, and the way tribunals properly apply national law. How do they determine, how they address national law through experts, and whether they can delegate to experts part of the reasoning in relation to contracts, or the role of the experts is just to identify the legal regulation, but not to suggest how a particular contractual term shall be interpreted. Another conclusion to which I came is that tribunals possess this power to interpret contracts, and that probably it might be helpful if we will look at contract interpretation as an incidental issue, the concept which we have in private international law. And through this concept or through this prism, it might be easier to agree on application of national law, regardless of the status of national law as being part of applicable law in investment treaty arbitration or not. And it might be helpful theoretically to approach this type of legal reasoning through the concept of incidental issue. Finally, and I will probably stop here, one may ask, why does it matter and whether it matters at all? And in my view, an important or big portion of critiques against investment treaty arbitration relates to quality of legal reasoning. And the predominant part of critique relates to treaty interpretation, primarily because bilateral investment treaties, the first generation of this kind of treaties, which are more intensively put into application, they're rather short and not detailed, and that opens the door for broad interpretation. But also, we have a spectrum of application or non-application or improper application of domestic law in this field. And here, where my research, I believe and hope, will contribute, will raise a question on proper interpretation and will contribute to correctness and quality of legal reasoning and its predictability. Thank you.
Thank you, Julia. It's quite interesting. Do you think there is any difference in how the investment treaty tribunals address this issue if we compare this with like standard commercial arbitration tribunal?
There are some differences in the intensity of addressing these issues, because in commercial context, contractual dispute is in focus, and tribunals has to interpret, has to determine applicable law and acts in the framework of applicable national law. Whereas in ISDS, it is public international law, which is the primary framework, and tribunals are not resolving contractual disputes as such. Of course, umbrella clause may open some room for other views in this regard, but tribunals primarily apply public international law. Therefore, the intensity of their reasoning and engagement with contractual analysis or contractual interpretation is rather different. But from the normative perspective, or in other words, from the perspective which law should they apply to the part of their legal analysis on ascertaining the content of contractual provisions, the answer should be the same. It should be the same approach as in a commercial arbitration. The proper law of the contract should define how that contract is understood, in my view.
Thank you. So it's not unusual when the outcome of the commercial case would depend on the issue of interpretation of a contract. But could this be also true for investment treaty arbitration?
Of course, that can be quite central for some of the cases, particularly for those cases where we have, for instance, part of legitimate expectations being based on contractual undertakings. And if a foreign investor, for instance, insists that, for instance, fair and equitable treatment was violated, and as an element of fair and equitable treatment, a private investor is relying on certain contractual undertakings, then it becomes quite central to understand what kind of undertakings. And if, for instance, a contract is open for implication for some other terms, the question arises on which basis can you imply certain contractual terms, and on their basis in result, can you do something with legitimate expectations in this regard or not? And in result, can you suggest that fair and equitable treatment was violated or not? So occasionally, and not only on quite debatable umbrella clause provisions, but also for more commonly used fair and equitable treatment or provisions relating to expropriation, contracts may become critical, and their construction and their interpretation may affect the entire outcome of the dispute.
Thank you, Julia. It's very interesting. Before we move to our next topic, I would like just to say a couple of words to our participants. So if you have any questions, you could just use this YouTube mechanism and type them, so we will see the question and we'll try to address it after all the presentations. Moving to our next topic. So we all know that investors are trying to find the best ever possible treaty for their claims and for future proceedings. And the issue of treaty shopping is one of the most discussed in this context. Aycan, could you tell us about developments in this regard?
Thank you, Olena. First of all, I would like to thank to you and to Ukrainian Arbitration Association for organizing such a useful webinar with distinguished speakers. And also, I would like to thank to Barton and Julia for their very useful and enlightening speech on emerging issues of the investment arbitration. So, in fact, my topic is also related to the consistency of the investment arbitration, namely treaty shopping and abuse of process, because I consider that the treaty shopping and abuse of process is another emerging issue which the arbitration tribunals should take into consideration for both protecting the rights of investors and also the rights and interests of the states. So first, I can start with my introduction on treaty shopping and abuse of process. After the increase of the execution of bilateral investment treaties and development of investment arbitration, some new issues have raised, and one of them is the treaty shopping. So what is treaty shopping? In fact, the treaty shopping, maybe while I'm explaining, I can also share my PowerPoint as well. Just a second. So just a second. Yes. So what is treaty shopping? In fact, the treaty shopping can be defined as the possibility of the investors to choose another bilateral investment treaty other than the original bilateral investment treaty to get access to more favorable jurisdictional and substantive provisions. So here we need to focus on the timing of the corporate restructure, because if this corporate structure, I will explain this in a detailed manner within a few minutes, but if this corporate restructuring occurs after the dispute arose between the state and the investor, then we may consider this action as an abuse of process. But it doesn't mean that the investors do not have right to select another bilateral investment treaty, especially before the dispute arose between the investor and the host state, or this dispute is not foreseeable between the state and the investor. So a treaty shopping, as I said, can be considered as a technique for the protection of investment or investment claim to gain, enhance, or facilitate access to international investment arbitration with more favorable conditions. However, a distinction should be made between early stage and late stage of the investment. Early stage treaty shopping occurs when an investment structure is planned in advance, namely before the dispute arose or the dispute is not foreseeable between the state and the investor, so that the investment and the investor may benefit from the more favorable jurisdictional or substantive provisions of another bilateral investment treaty or multilateral investment treaty. On the other hand, late stage of treaty shopping occurs when a corporation restructures an investment after a dispute has arisen or become foreseeable to gain access to more favorable conditions for investor-state arbitration. So we can say that this is generally called abuse of process. For instance, in an exit case, Alaplı versus Turkey, the arbitrator Bridget-Stern found that the dividing line between a good faith restructuring and a bad faith restructuring occurs when the relevant party can see an actual dispute or can foresee a specific future dispute as a high probability and not merely a general future controversy. Of course, there are some criticisms about treaty shopping. The rationale behind this criticism is that, in principle, the international investment regime grants protection to an investment because of the investor's nationality. As you know, the main purpose of the bilateral investment treaty is to protect and encourage the investments of a national, of a state, which aims to make an investment in the other state, and these states are the contracting states of this mere bilateral investment treaty. Therefore, any attempt to change the nationality may raise a doubt for contradicting the modern foreign investment regime. To reduce this practice, international investment the other remedy is the denial of benefits clause, which can be put into the bilateral investment treaties. The denial of benefits clause is an invention in international investment law, where the states include a denial of benefits clause within a BIT to prevent the investor from restructuring its investment to change the nationality. Of course, the denial of benefits clauses are not limited with this purpose, but this type of clauses can also be used for preventing possible abuse of rights or abuse of process. On the other hand, the abuse of process is not prescribed under the bilateral investment treaties, and they are only subject to this doctrine is only subject to the interpretation of investment arbitration tribunals based on the specific facts of each case. For instance, the abuse of procedure is defined in the commentary on the State of International Court of Justice as a special application of the prohibition of abuse of rights, which is a general principle of international law as well as municipal law. So here, when we need to consider the legal basis of the doctrine of abuse of process, we can say that the doctrine of abuse of process is a part of general international law. Similarly, some exit tribunals also confirm that the doctrine of abuse of process is a principle of general international law. For instance, Phoenix Action versus Czech Republic, the arbitration tribunal concluded that the only investments made in compliance with the international principle of good faith that do not attempt to misuse the system are protected. A claim based on the purchase of an investment solely for the purpose of commencing litigation is an abuse of process. Similarly, another exit tribunal in Churchill and Planet versus Indonesia held that the theory of abuse of process, which is a variation of the prohibition of abuse of rights, and like the latter, an emanation of the principle of good faith, find application in the context of inadmissible corporate restructurings. And that theory is another manifestation of the general principle that one does not benefit from treaty protection when underlying conduct is deemed improper. Another tribunal in Karatyup versus Kazakhstan also came to a similar conclusion and confirmed that the doctrine of abuse of process is a part of general international law. So right now, I would like to point out another specific issue within the context of abuse of process, and this is internationalization of domestic disputes. Generally, bilateral and multilateral investment treaties are executed between the states to encourage and protect the foreign investments, not the national investments or domestic investments. So consequently, a domestic investment in principle should not be subject to any international investment arbitration, since the states do not have consent to bring their disputes with national investors to an international investment arbitration. Having said this, in practice, on the other hand, we can see some attempts of the national investors, which can be also considered as an abuse of process, where the original investors are in fact the national of the host state. In case where there is a domestic dispute between the state and the investor, who is the national of the host state, this investor may also try to internationalize its investment or dispute with the state by transferring its shares in the local company to a foreign investor, to a foreign company, in order to be able to file an investment arbitration against that host state. Therefore, the abuse of process may occur when the national investor restructures its investment to internationalize the dispute with the state, and even where the claimant, the alleged foreign investor, was not a party to the dispute, to the domestic dispute. So here again, the timing is very important to understand whether the foreign investor made this investment or decided to purchase the shares of the local company with good faith or in order to internationalize this dispute. So in order to conclude that there is an abuse of process in internationalization of a domestic dispute, following conditions should exist, or at least we can say may exist. Sufficient evidence proving that both the national and foreign investors who are the parties to internationalization transactions were or should have been aware of the dispute between the national investor and the state, or at least it was clear for these parties that a dispute is foreseeable between the national and the host state. Second condition can be their sole purpose is to internationalize the dispute in order to file an arbitration case against that host state. And finally, there is no financial or economic contribution by the foreign investor other than a simple acquisition of the shares, assets of the company in the host state. Previously, Republic of Turkey came across with these kind of claims, which can be also considered abuse of process and also held by the exit tribunals in this regard. For instance, the exit tribunal in Europe Cement versus Turkey held that a claim based on the false assertion of ownership of an investment is an abuse of process. In this case, the tribunal determined that there was no investment at all by the foreign investor at the time when the domestic dispute arose, and found that the claim's assertion that the tribunal has jurisdiction based on the ownership of the shares was false. Finally, the tribunal, by relying on Phoenix case, stated that if, as in Phoenix, a claim that is based on the purchase of an investment solely for the purpose of commencing litigation is an abuse of process, then surely a claim based on the false assertion of ownership of an investment is equally an abuse of process. Similarly, another tribunal in Sementaunio versus Turkey determined that the claimant intentionally and in bad faith purported to be an investor when it knew that this was not the case. And this constitutes an abuse of process. So now we can continue with the suggestions that may prevent the abuse of process. So what could the states or the legal councils of the states may prevent abuse of process, or what kind of suggestions can be considered to prevent abuse of process, especially to prevent the internationalization of domestic disputes? The first suggestion can be the establishment of the standards to be applied by the arbitration tribunals to determine whether there is an abuse of process. As you know, there are standards which are generally applied by the investment arbitration tribunals to determine the existence of investment in the host state. The most well-known standard or test, we can say, Salini test, which was created by another exit tribunal in Salini versus Morocco case, and which provides some conditions such as contribution of economic or financial contribution by the foreign investor, duration of the investment, risk assumed by the investor, and the profit return expected by the investor. So similarly, in order to prevent the abuse of process, the exit tribunals or any other investment arbitration tribunal may create or determine a test, same as Salini test. And when we look at this test, following conditions can be considered as the relevant criterion. The first one is the existence of evidence proving that both the national and foreign investor who are the parties to the internationalization transactions were or should have been aware that there is a dispute between the national investor and the host state, or such dispute at least foreseeable. The second one is the party's sole purpose is to internationalize the dispute in order to file an arbitration case against the host state. And finally, there is no financial or economic contribution by the so-called foreign investor other than the simple acquisition of the shares or assets of the local company in the host state. Another suggestion can be putting several denial of benefits clauses into the bilateral investment treaties. These provisions can be put into the BITs to define legal person or real persons investors by way of adding several requirements with respect to the seed or substantive business activities, define investment by way of adding several requirements such as financial contribution other than simple acquisition of shares or assets of the company, and finally, describe the conditions under which a corporate restructuring is accepted. For instance, refusal of restructuring after the domestic dispute arose with the host state or after it became foreseeable. So this is the end of my presentation. Thank you.
Thank you very much. As you mentioned, one of the central points of treaty shopping and abuse of process is the issue of time and the issue of foreseeability. And the last one is particularly not easy to answer probably, but how could you describe foreseeability within the context of due process and abuse of process, sorry?
I can say that at least from the cases that I heard or that I'm involved, the high tension is focused on the concept of foreseeability, because when a state raise an argument before the investment arbitration tribunal about abuse of process, the most important argument coming from the investors is this dispute was never foreseeable or did not occur. So the foreseeability can be determined by the tribunals in terms of the specific facts of each case. For instance, we can say that I'm talking about the internationalization of a domestic dispute, for instance. If there is an investigation or if there is an local proceedings, criminal or tax proceedings initiated already against a national investor or a foreign investor in that host state, then this can be considered as a sufficient evidence proving that there is a foreseeability for that investor for the near future, because there's already an investigation ongoing against this investor. On the other hand, most of the tribunals do not accept some, for instance, political statements of the political parties. For instance, during the eve of the elections, if any party makes a statement about the energy regulation of that host state, and after this party won the elections, then if there is a dispute, investment arbitration dispute in the future, just mere explanations or statements by the political parties or any other state institutions cannot be considered as a specific dispute or foreseeability, because it cannot be considered as a solid issue for this specific investor. Of course, there are lots of other examples, and I'm sure that other distinguished speakers have also some similar examples from their practice, but these are just the similar or maybe common examples that I can give right now.
Thank you. And my last question to you. In order to prevent abuse of process, do you think any additional requirements are necessary in terms of definition on investment and investor? And if so, why?
Yeah. So maybe in order to save time, I can just briefly say that the additional requirements can be the ones which shows that the investor, the foreign investor, made an investment in that host state with good faith, without any purpose to just a sole purpose to file an arbitration case against that host state. So these requirements, that's why, can be the serious financial contributions other than simple acquisition of the shares of the company, and similar other contributions for the development of the economic development of the host state, and also the evidence that the foreign investor is not a shell company in its home country. I can say that these are the most important examples.
Thank you very much. We have a question from our participant, Evgeny Vasilchenko. And he asks your views on whether the application of broadly worded MFN clauses containing many modern BITs can make an ISDS reform meaningless, and if so, how this should be addressed. So who would like to take to answer the question? Julia, Barton, please.
Probably I can start, and Barton will help me if I'm taking something wrong. Basically, we can define reforms of two directions. The reform which Barton addressed relates to possible creation of international court and dispute resolution system or mechanism. There is another line of reform which is I would say more efficient probably, and it relates to reforms of the content of bilateral investment treaties. We have a new generation of bilateral investment treaties, new models for the states, and the content of treaties becomes more and more carved, more detailed, and MFN clauses are taking also more sharp and shape in these new treaties or new generation treaties by excluding certain areas to which they are not applicable. And the response to the question would be, yes, in essence, MFN may be viewed as connecting the entire world of bilateral investment treaties, but each MFN clause should be analyzed alone, because they are not uniform, they are rather diverse, and there are a number of already dissertations focused entirely on MFN clauses. They are diverse. There are a lot of problems with application of MFN clauses for procedural purposes. And the only answer to this for future treaties and for future reform is to pay attention to this clause, to carve out what shall not fall into its scope. And that's what happens actually now, in my view.
Thank you, Yulia. Martin, would you like to add anything?
Sure. I guess, it's difficult to predict exactly what shape the reform of the ISDS system will take. But it is likely that if there is agreement, multilateral agreement on a reform to the system, the form of that agreement will likely look a bit similar to the recent EU member state agreement on the termination of certain bits, where you have the main treaty with the text that now applies, and then an annex that lists all of the treaties to which that text applies. So it's likely that, let's say there is a treaty instituting a new international investment court. It's likely that there'll be an annex to that treaty that lists the bilateral investment treaties that the parties to it want to be affected by this development, and modifies the arbitration clauses of those other treaties. So I would think that it would be difficult to get around the reform if it takes that shape. Now, there are some treaties, like the model United Kingdom bilateral investment treaty, that have a fairly explicit provision that applies the MFN clause to dispute settlement. So for those treaties, either the reform will have to modify that provision, which is a possibility, or the question will be whether the new system is in fact more favorable, because an MFN clause only applies or is only going to be invoked if the other treaty is more favorable than the current treaty. So what is probably more likely, given the direction of ISDS reform, is that an investor that still has some capability of claiming under one of those earlier treaties will continue to do that. But I'd be surprised if the MFN clause made it a significant difference.
Thank you very much for your answers. So as we are already exactly in time, so 1 hour, and we do not have any other questions. So unless you have any issues, further issues to discuss, I would like to say a couple of, to thank our participants for being with us, to thank you for your presentation and for your time. I would like to inform our participants that Ukrainian Arbitration Association will host other webinars as well. And our next webinar will be a joint webinar with Arbitration Institute of the Stockholm Chamber of Commerce, and would be devoted to ECT disputes, and would take place on 26 November. So stay with us. Thank you very much for your attention. Bye-bye.
Bye.
Bye.